Put your hands up, yeah. To the floor, yeah. Yeah.
That's right.
Come down, selector.
That's right. Come on.
A day after the state announced its investigation found the Minneapolis Police Department violated civil rights laws, we are digging deeper into the tool that can hold the department accountable moving forward. It is called a consent decree, and it's been used across the country to reform police departments. Jennifer Hoff's here now with more on how it works and when people could see some change. Jennifer?
Julie, it's important to note that the parties involved are just in the very beginning stages of what is a very lengthy process, but one that does have some leverage. Because a consent decree is legally binding, it sets timelines, and it uses an independent monitoring group to regularly report any progress. On Wednesday, the Minnesota Department of Human Rights announced its investigation into the Minneapolis Police Department found it engages in illegal racial discrimination, a pattern it laid out in a report after reviewing thousands of pieces of data from the last 10 years.
Without fundamental organizational culture change, reforming MPD's policies, procedures, and trainings will be meaningless.
The next step, she said, is to negotiate with MPD and the city to develop a consent decree that lays out specific changes to make. The legally binding state agreement is similar to federal ones used after police killings in cities like Ferguson, Baltimore, and Cleveland, where Dr. Ronnie Dunn is an urban studies professor.
I think it's the best viable tool.
He's also a member of the Cleveland Police Monitoring Team, instituted after that city entered into a consent decree 7 years ago, when the Department of Justice ruled the police department had a pattern of excessive force.
Many police departments are working towards reforming. We have a considerable ways to go.
There will be a similar group to monitor MPD, but Dunn cautions it can take up to a year to form, made up of lawyers, psychologists, and data experts who engage with the community to identify the problems and regularly report any progress to a judge that's also posted publicly. And there's no telling when a consent decree may be met. Oakland police, for example, have been under federal watch now for 19 years after residents filed a lawsuit because some officers planted drugs and beat up citizens.
They have to reach compliance, and until they do, they will be under those reform measures.
And the Department of Human Rights says in the coming months, it will be meeting with community members, MPD, and city staff to get some feedback on what they think should be in the consent decree here. As soon as that's developed, it says the monitoring team will then be finalized. There is a link, by the way, where you can submit your ideas for change that we posted in this story at KARE11.com. Back to you.
Thank you, Jennifer. Well, that human rights report is extensive. If you'd like to read it in its entirety, you can text the word report to the number on your screen. And please remember, the link request only works if you text the number, not call it.
We want to welcome everybody to You and the Law podcast show. I'm one of the co-hosts of the show, Virgil Green. And as always, the dude has kind of cut his beard down a little bit. He goes by the name of Chief Swaggy One. How you doing, brother?
What's going on? How are you?
Pretty good, pretty good. Well, hey, we want to jump right into the podcast. We've got he's no stranger to the podcast, but we got on who I consider a special guest on our podcast show, Bob Scales, who is the CEO of Police Strategies LLC. So, Bob, glad to have you on again.
Well, thanks so much for having me.
Yeah, I keep up with you on LinkedIn a lot, and you're an expert, I believe, in this conversation when we talk about consent decrees. You write some pretty detailed responses to those agencies who are finding themselves going through something that you have a lot of experience dealing with up in Seattle.
Yeah, I have a lot of opinions about consent decrees. I don't know if I'd call myself an expert, but
Yeah. Well, Bob, why don't you tell our guest a little bit about yourself, and then we'll get into the topic.
sure. So I am an attorney, and I started out as a prosecutor in King County, Washington in the 1990s. And then I moved to the city of Seattle, and I worked for several Seattle mayors as a public safety policy advisor. I then moved to the city attorney's office, and I was there in 2011 when the DOJ came in and did a pattern of practice investigation of the Seattle Police Department. And I represented the city in that investigation, and worked with the DOJ on making sure that they had everything that they wanted. And then when they issued their findings letter, I led the negotiations. And although my recommendation was not to sign the consent decree, the city ended up entering into a consent decree. And then the mayor appointed me to be the compliance coordinator in the police department to oversee the reforms. And I did
Okay.
that for about a year and a half. And then I left the city and formed my company, Police Strategies. And our sort of mission is to help law enforcement agencies collect, analyze, and report on their own data, mostly use of force data, to both understand their own practices, as well as help educate elected officials and the public on use of force.
Okay. So, Bob, for a lot of people, they don't really know what a consent decree means. So you kind of explained a little bit about it, but for those listeners who are not familiar with what a consent decree is and how an agency gets to that point, can you kind of give a little overview of that?
Sure. So the consent decree is authorized by a federal statute, 42 USC 14141, and that was passed in 1994 under a crime control bill. And it really was the result of the Rodney King incident, where officers were obviously caught on video beating Mr. King. They were acquitted in state court, and then some were convicted in federal court. And obviously there were riots in between. But basically there was a concern that it wasn't just these officers, but there was a bigger systemic problem in policing. And so the statute gives the Department of Justice the authority to investigate local law enforcement agencies. These are civil investigations of local law enforcement agencies for a quote unquote pattern or practice of unconstitutional policing. And if they find a pattern or practice of unconstitutional policing, then the DOJ can file a civil lawsuit in federal court to essentially force the city to reform, institute remedial measures to eliminate the pattern or practice. That typically doesn't happen. And what happens is that the city will voluntarily sign the consent decree. And so the DOJ has only had to ever go to court once, and they lost. And so almost every single time, the city voluntarily signs the agreement rather than having DOJ go to court and prove their case.
Okay. So kind of going back to, your time with Seattle, when you stated that you didn't recommend that the city sign the consent decree, kind of walk us through that. What was some of your concerns as to why you made that recommendation? And also, since the city, they didn't follow that, what was the outcome?
Sure. So before the DOJ did their investigation, Seattle PD was held up by the federal government as a model agency. We received a lot of praise from DOJ and the cops office. Our chief of police was Gil Kurlikowski, who went on to be President Obama's drug czar and then the head of Customs and Border Patrol. We were one of the first agencies to adopt de-escalation training and crisis intervention teams. We had a 3-tier civilian oversight structure for our complaints. And we had an extensive community engagement and community policing model that was implemented. But in 2010, there was a high-profile shooting incident involving a Native American man, and it was a bad shooting. And the police department had a firearms review board, and they immediately held a firearms review board and found the shooting to be unjustified. And the officer was immediately fired, and the case was referred to the county prosecutor. They wouldn't file charges. Then it was referred to the U.S. attorney, and they wouldn't file charges. There was a civil lawsuit that was settled for $1.5 million. But basically, there's no question it was a bad shooting, and the department took immediate action to remove the officer and mitigate the damages. And so there were also a number of this is sort of when cell phones are starting to come on, and so you had a number of lesser, not lethal uses of force, but lesser uses of force, usually physical force, that were captured on video that were repeated over and over again in the media. And so what happened was that the U.S. attorney asked a number of community organizations to write a letter, and there were 30 organizations that signed a letter. And the letter requested that the Department of Justice conduct a pattern of practice investigation of the police department. So they started their investigation in March of 2011. And we provided them with hundreds of thousands of records. And we were convinced there's no way we could possibly have a pattern of practice of unconstitutional policing. We had a very low complaint rate. We had a very low litigation rate. We had best practices in virtually everything. There's no way. And we had a very thorough use of force review board, firearms review board. We had no fear. So we provided them with everything. We were an open book. And then late one night in December, the U.S. attorney summoned the mayor. So we didn't hear anything about the investigation for 8 or 9 months. And then late one night in December, the U.S. attorney summoned the mayor and the police chief to her office and announced that the next morning, Tom Perez, the head of the Civil Rights Division, and her were going to do a press conference and announced that we had a pattern practice of unconstitutional policing. And we said, what? Everybody went sort of crazy. It's like, what's going on here?
Okay.
And so among their claims was that 20%, so they looked at 2.5 years worth of use of force cases. And they claimed that 20% of those cases, which would have been about 250 incidents, were unconstitutional. And Seattle PD had already reviewed those cases and determined that they were within policy. On average, Seattle PD would find, less than 2% of all use of force to be out of policy. And only a rare case, such as the bad shooting, that are unconstitutional or unlawful. So we said, there's no way that number's correct. So show us your data. Show us the cases that you found to be unconstitutional. And DOJ refused. And we said, well, show us your methodology. How did you come up with this number? They refused. So they would not show us anything. And they would not identify a single case that they found to be unconstitutional. And what they said was, you just have to do the consent decree. The number doesn't matter. 20%, 15%, that doesn't matter. This is what we found, and you have to do a consent decree. And so the second option we did was, all right, let's set that aside, whether we have 20% excessive or unnecessary force. We will voluntarily implement any reform measure you want. If you don't like our use of force policy, you think there's a better one, we'll do that. If you want improvements made to our training programs, we'll do that. You just tell us what you want. But we don't want to have $1 million a year monitor. We don't want to have to report to a federal judge. We will voluntarily do everything you want us to do. Nope. They refused. They said, we have to force you. The reforms will only work if we force you to do them. And the only way we can do that is with an expensive monitor that you pay for and a federal judge. So we went through about 6 months of negotiating with DOJ. And during those negotiations, I routinely said, they can't prove this. If we say no, they have to go to court and prove it by preponderance of the evidence that we have 20%, excessive or unnecessary. There's no way they can prove it. So don't agree to this, because if DOJ goes to court and they prove their case, the worst thing that can happen to a city is a consent decree.
Consent decree.
Nothing. There's no other penalty.
Mm-hmm.
So why would you agree to something where there's no evidence that you have a problem?
Okay.
But politically, so just real quick, so the city council and the city attorney that I worked for, who was separately elected, were very much against the mayor and against the police department. And so what ended up happening was that if the mayor didn't sign the consent decree, then probably the city council president would have signed it, even though and so basically the mayor made a decision that he couldn't refuse. Basically they made him an offer he couldn't refuse.
Bob,
I guess a political decision.
Yeah, Bob, let me ask you a question. You mentioned something about cost, and I think that the listeners may not understand that these are not free. This is not free resource. This is not free oversight. Could you kind of explain to them, the listeners, exactly what that entails when we start talking about monitors and we start talking about going back checks and balances and stuff? So we're not talking about an overnight fix. We're talking about there's still some departments that are still under consent decree.
Yep, including Seattle,
Yeah.
still under a consent decree. So the important thing to recognize is that DOJ brings nothing to the table. So they will not give you one penny in support. They will not offer you any technical assistance. They will not hire any experts to help you. Everything is paid for by the local taxpayer. Everything's paid for by the city.
Mm-hmm.
And when we were negotiating with DOJ about the consent decree, we estimated that the consent decree would last 5 years, and it would cost $60 million. And we stated that publicly. We said we told the city council, this is what we think we think we can comply in 5 years, and we think it's going to cost $60 million. DOJ went crazy. They said there's no way it's going to take that long, and there's no way it's going to cost that much. It has taken 12 years and is ongoing, and has cost more than $200 million. So 3 times our estimate, more than 3 times.
And to the listeners, the most recent one that I know of, and you may have mentioned that regarding a law going to court, is Ferguson. I know that was one of the biggest things that the mayor of Ferguson was concerned about, was the cost. Was that the department you were talking about that went to court?
No, there was the only department that went to court was a sheriff's office, the sheriff of Alamance County in North Carolina. Very small sheriff's office, yeah. Okay. And the sheriff refused because the sheriff was separately elected.
Right.
He could say no, right? And he did. And DOJ filed a lawsuit, and they lost.
Yeah.
I know that Ferguson, that was a big deal in Ferguson. When they laid out the investigation, and it was determined that they would be put under a consent decree. And I was telling someone, they were like, the council's going to have to vote or whatever. And so they can't make them do that. I said, oh, yeah. yeah, they can, especially with the political atmosphere that was occurring in Ferguson.
Yeah.
And
especially a small town like Ferguson. I mean, basically, consent decrees can bankrupt cities.
Yes.
And if they don't bankrupt a city, what they do is they divert money from community services to the police department, because DOJ and the federal judge and the monitor can force the city to spend more money on the police department that they otherwise wouldn't spend, and it has to come from somewhere. So they have to cut other community services in order to do that. And
Yeah.
so,
Bob, do you think, Bob, let me ask you this. Do you think that there's another avenue that can be taken? Because I know that there have been some departments that, let's take Albuquerque, Albuquerque, Chicago, LA. And it seems to be that it actually is working in Albuquerque. It seems that it was actually working in New Orleans, to the point New Orleans has come out to have an amazing mentoring program, a model program throughout. But you don't hear the things you used to hear in New Orleans. So do you think that it should be like maybe a tiered approach where you have this consent decree, and this is what it's going to cost a major city, and this is what a mid-sized city, or this is what a small city can afford. I mean, to me, it's like, and I guess what I'm asking is like you have CALEA, that's very expensive, but then now the local states are having accreditation processes for those police. So could there be an approach like that, maybe?
absolutely. I mean, I do not disagree, and no one disagrees with DOJ's goals and objectives, right? DOJ wants to have constitutional policing. Every police chief, every sheriff wants constitutional policing. Nobody's arguing, yeah, we want officers to be able to, violate the law and violate the Constitution. Nobody says that. So we're all on the same page about what the end goal is. The question is, how do we get there?
Sure.
And so DOJ and the federal government obviously have far more resources than a local city and a local police department.
Yes.
And what they need to do is to create a collaborative reform program. And so if they find an agency that has a problem, they can offer help and assistance to help them improve. And if the city agrees, if the police department agrees, which I think almost every police department or sheriff's office would, if the DOJ came in and said, we want to help you improve, and we're going to bring in funding and expertise and resources to help you, nobody's going to turn them away.
Mm-hmm.
It's like, that's great. And so that could achieve the results that DOJ says that they want. And they could do a lot more of those than they could consent decrees. And it would work. It would actually help agencies improve. And if the agency had a clear problem and they refused and they said, go away, DOJ, we don't care, we're going to do what we want to do, then the DOJ can do their investigation and lawsuit and consent decree. But that's probably never going to happen because, I mean, I'll guarantee you that Minneapolis and Louisville would love to do a collaborative reform model with DOJ. They're not going to tell DOJ to go away. And it would work. And it has worked in the past. And the COPS office at DOJ used to have that kind of model under the Obama administration. And then it was done away with in favor of the Civil Rights Division and consent decrees.
So, Bob, let me ask you this question. So with the federal monitors, and you got a pretty good knowledge, or you've dealt with federal monitors. Is that something that a federal monitor would say, hey, listen, would that federal monitor have some kind of input as to what you just explained to the listeners, to where that federal monitor may say, hey, instead of us going down this typical road that we have went down before, why don't we do this here? Or is that just out of the scope of the federal monitor?
Yeah, so federal monitors only exist or only come into existence when there's a consent decree. Mm-hmm. And they are basically created from scratch. There's a request for proposals. You'll get proposals from a bunch of law firms or private consultants, and then the city and the DOJ will choose one. And a federal monitor gets paid about $1 million a year minimum for a large city. Minneapolis, their monitor for the state consent decree was $1.5 million a year.
That's a lot of money.
Yes, and all they have to do is produce one or two or maybe quarterly reports and say whether or not the department is in compliance. The monitors only get paid as long as the consent decree is in place. Once the consent decree goes away, the monitor's job ends. So there's an immediate financial conflict of interest So the monitor has no incentive at $1 million plus. I mean, the Chicago monitor is making $3.5 million a year. They have no incentive to find compliance. And so that's one reason why these consent decrees go on so long. Also, the monitors are not there to help. They're not there to assist the department in any way, shape, or form. They're only there to tell you what you're doing wrong. And also, there's no required qualifications to be a monitor. Anyone can be a monitor.
Really?
Yeah.
So you don't have to be. You don't have to be a. I've heard of retired police chiefs being a monitor, or I've heard lawyers being monitors. So
yeah, that usually they are, but you know, they don't. It's not. They don't have to have. It's not required, right? You can be anybody, right? And so usually a monitoring team is made up of a variety of individuals, but it's just a sales pitch, right? They're making a sales pitch to the city and DOJ. Pick us, you know, because we'll do the best job. But none of these monitors, or most of the monitors, don't have any experience being a monitor. And then what happens is that monitors from prior consent decrees try to get on monitoring teams of new consent decrees so they can keep their lucrative paychecks going.
Yeah.
So and the Government Accounting Office, the U.S. Government Accounting Office, did a report in 2021 saying how messed up the monitoring system was, and DOJ itself did a memo saying how messed up the monitoring system was, and said they were going to correct it, but they haven't done anything to change it. You know, they haven't put any salary caps, they haven't put any term limits on them. It's a racket. So the monitors are completely sort of separate. They only come into place after everything's in place, and then once they get hired, they go to town and make as much money as they can as fast as they can.
Yeah. Well, Bob, you just answered a question in the chat room from one of our listeners. You know, what are the qualifications to be a monitor? And you already answered that question. So, which is absolutely, there's no qualifications other than somebody knowing somebody.
Well, Virgil, I think what he's saying, and Bob, please correct me if I'm wrong. It doesn't mean that you can just go and get a Joe off the street. It means that you don't have to be an attorney. You don't have to be a police chief. You know, I mean, is that what you're saying?
Practically speaking, what you need to be a monitor are political connections.
Yeah.
So a lot of monitors are former DOJ officials, or attorneys that have, you know, worked in the U.S. Attorney's Office, or retired police chiefs who are involved in a lot of, you know, organizations and so forth. Mm-hmm. And so there are entire consulting groups that have been set up in order to pursue these lucrative monitoring contracts. But there's no like list of required qualifications to be a monitor. But practically speaking, you need to have political connections to get that kind of lucrative contract.
Yeah. Well, you know, Bob, and just kind of touch back on how much money this is costing the taxpayers. And I don't think a lot of people really think about that, because let's just say the city has given the police department a $28 million budget. And now here's an agency that is coming, or even a $300 million budget. Now all of a sudden, here you find yourself under this consent decree. And so now the city has to stop and say, okay, how are we going to pay for this consent decree? And the average taxpayer doesn't even think about that.
It's really robbing Peter to pay Paul, because you know something's going to suffer. Some department,
something is going.
Some department's going to suffer, or something's going to get cut out of the police department. But at the end of the day, how can you cut anything out of a police department that's under a monitor? You know,
well, exactly. You can't cut anything. I mean, that's the thing. And one of the ironic things is that some of the biggest supporters of consent decrees are those that also want to defund the police. Mm-hmm. And you can't do both. In fact, if you have a consent decree, you go it's refunding the police, right? Mm-hmm. Because DOJ and the monitor will say, we need better IT systems, right? We need more training, right? We need civilian oversight. We need, I mean, it's the list goes on and on. It's never ending. I mean, Seattle had terrible IT systems before the consent decree. And they spent $25 million to hire Accenture to build a data analytics platform that the Monitor wanted. And it's a great data system, but that's $25 million that had to come from somewhere else in the city budget.
Mm-hmm.
And more than $200 million, including more than $12 million for the Monitor, had all that came from local taxpayers. And that meant that other departments and other services had to be cut. So if you want a consent decree, you have to be prepared to spend a lot more on policing.
Well, obviously, that would impact other, like you said, other city services. So if you got a lot of large potholes, there's going to be some potholes not fixed in public works. And if you got parks and recs, that means some swimming pools may not be open during the summertime. So there's going to be across the board some services cut because of the police department.
Hey, Virgil and Bob, what's interesting? Like right now, Louisville's under a consent decree. And at the same time, they're going through a chief search. And there's a lot of qualified applicants out there that will tell you, I don't want to touch that. I want no part of that going into an organization where I'm not really running my police department. I mean, I'm the chief, but
you're not in control.
Yes. I'm being told that I can sneeze now. I can't sneeze now. And I'll give you an example, Bob. Albuquerque. I have a friend of mine that applied for Albuquerque, and it was going to actually be two chiefs. It was going to be a chief. This is interesting. There was going to be a police chief. We're hiring her to be the police chief. However, they had a police chief over training because training was the main focus of the consent decree. So they were going to have two police chiefs. And she was like, I want no part of this. I can't. I mean, how can you have a chief over the training and a few other bureaus and then a chief over the department? That's not going to work. But that's where they are in Albuquerque.
Yeah. Well, Bob, one of the things, the mayor and I think you talked about this, the mayor in New Orleans has stated that she doesn't want to sign this consent decree. And I think there's been a lot of conversation back and forth about that over the last couple of months. Is that accurate, or is that?
Well, New Orleans is under a consent decree, and what's happening is, and they've been under for I don't know how many, 8 or 9 years. And what's happening is that the mayor and the police chief are saying we're in compliance, and we've been in compliance for some time, and we want out.
Okay.
And the Monitor's saying, no, I'm not going to let you out. And the judge is the only one who can decide if they're in compliance or not. And so the judge doesn't want to let it go either. So basically the mayor's saying, we're done, right? We're done with this thing. And we've done all we're going to do. And what her argument is that the Monitor and DOJ have keep moving the goalposts, right? And this does happen a lot, is that once you've monitored a police department for a few years, you realize that, hey, there's a lot of other improvements that we can make while we're here. So let's add this and this and this and this. And that's what's happening in New Orleans and most other consent decrees. And so the mayor's basically saying, look, you told us to do this. Here's what our agreement says. We're done. And we want out. But the judge isn't going to let him out. And the Monitor's saying, no, you're not done. So I don't know what's going to happen there when because it's very unclear what authority does the judge have. I mean, is she going to call in the National Guard or something to take over I don't know.
Yeah, well, and I guess that was my next question. Let's say New Orleans says, hey, we're through, we're done. Does that federal judge or have the authority to say, hey, you're in violation of this here? You could be subject to some kind of federal indictment or go to.
Well, that's the thing, is that this is a civil matter.
Yes, a civil matter.
And there's no monetary damages. So if you're in a civil matter and the only thing is this consent decree, and the judge orders you to do something and you refuse, there's no remedy. There's no way.
So I'm gonna ask you this question, Bob, and maybe this has never happened, but what if they just said, "Hey, we're not going to pay the federal monitor. We're not going to pay the judge." What if New Orleans or any other city said, "Hey, we've been under this for 7 or 8 years. You're not going to get another check from us"? What would
I don't know. It's never happened before.
I
I think if it's going to happen anywhere, it's going to be New Orleans, and it will be very interesting to see how DOJ and the monitor and the judge respond if New Orleans just walks away and says we're done, because I don't think they can do anything.
Yeah.
And also I do believe that New Orleans is probably in compliance. It's probably true what they're saying is that they have met all the requirements of the consent decree. I mean, the monitor in New Orleans is getting into individual misconduct cases and saying, I don't like this decision you're making. I want a different decision. And that's just way out of bounds.
Yeah.
And that's what basically New Orleans is saying. We're done with this stuff.
Yeah.
Bob, I have two questions. Do you think a department's history plays a role in that, or the monitor uses that in their favor based on the history of an organization?
Yeah, there's a lot of tactics that DOJ and the monitor use to basically use past problems. Minneapolis is a perfect example. So the DOJ pattern of practice finding is not about any individual case. And DOJ will tell you that. This isn't about, this case or that case. This is about a pattern of practice of misconduct. George Floyd, let me just see here. I counted the times. In the Minneapolis findings letter, George Floyd was mentioned 34 times. It's a 92-page report. George Floyd was mentioned by name 34 times. Mm-hmm. Derek Chauvin was mentioned 21 times in multiple incidents. Derek Chauvin was the only officer who is named in the DOJ findings report. So basically, they're arguing that there's this big pattern of practice and all these problems and everything, but they're focusing the public's attention on George Floyd because that's what makes people upset. And everybody knows about George Floyd. So they want to keep reminding people, George Floyd, Derek Chauvin, mm-hmm. and ignoring everything else. And the other thing that really upsets me about consent decrees is that, except for cases like George Floyd and Derek Chauvin, which have already been, the officers already been fired, already been convicted in state and federal court, that case has already been resolved. But what DOJ is saying is that there are hundreds of other officers in Minneapolis PD who routinely violate people's constitutional rights, and not a single one of them will be identified, and not a single one of them will be held accountable. And instead, we're going to blame the department. We're going to blame the policies. We're going to blame the training programs. We're going to blame the mayor. We're going to blame the police chief and his command staff. And all these officers that we are claiming routinely violate people's constitutional rights get a free pass. Nothing will happen to them. And that's another big hypocrisy of this whole thing. And what's happening in Louisville is that Louisville said, the community said, and even the city said, we want to know who these officers are that you think are so bad. Tell us who they are. DOJ refused. In Springfield, Massachusetts, they have a consent decree. They did a similar thing. Obviously a much smaller department, but DOJ issued a findings letter, routine violations of constitutional rights. Not a single officer or incident was named. The district attorney said, look, I'm the district attorney. If officers in our department are violating the law and you know about it, and I need to know, you need to tell me who those officers are so I can prosecute them. DOJ refused to give. So the district attorney is actually suing DOJ to get the names of the officers that DOJ says are violating the law. I mean, it's just crazy.
Mm-hmm. Okay. Well, hey, Bob,
Does that monitor, Virgil, that was the second part of that question I just had. Does the
oh, you
monitor
did?
does the monitor have any liability once they leave? Do they have any liability in this process? So if
No.
for some reason the department reverts back to past practices,
No.
okay,
The monitors are completely unaccountable. Nobody oversees the monitor. The monitor has a blank check. They can do whatever they want, whenever they want.
wow,
Okay. Okay. Well, hey, Bob, I'm going to ask you this question. Let me remind our listeners that you're tuned into You and the Law podcast show. Tonight's guest is Bob Scales, and we're talking about consent decrees. What are consent decrees? How do agencies find themselves under a consent decree? And so, Bob, one of the questions I want to ask you, have you ever seen a department that has these patterns of practice that do need to fall under some type of a consent decree or some type of monitoring for them to change their how they police their communities?
Well, one of the problems is that there is no definition of what a pattern or practice of unconstitutional policing is.
Okay.
We don't know. And DOJ doesn't know either. And I've heard them talk at conferences and say they don't know what the definition is. So in Seattle, they said it was 20%. 20% of our uses of force is a pattern, the unconstitutional use of force is a pattern of practice. And in the Washington, D.C. consent decree, which is a few years before Seattle, DOJ said they had a 15% excessive or unnecessary use of force rate. And in that consent decree, DOJ said a well-run department that does not have a pattern or practice, less than 2% of their use of force should be unconstitutional. And that would not be a pattern or practice. And I would actually agree with that number, because in the data that we do, we typically find that about 2% or less than 2% of uses of force are found to be out of policy. Nobody's going to have perfection, right? No officers are never going to make a mistake, right? So, and you will have officers who will violate the law and who should be prosecuted. Every major department is going to have problems. The question is does it rise? Are these problems caused by bad policies, bad training, bad supervision, bad accountability? That's what a pattern of practice is. It's like, it's not the officer's fault. It's these terrible policies and training programs. That's what a pattern of practice is. And I don't know any city or any sheriff's office or any law enforcement agency that I've seen that has a clear pattern or practice of unconstitutional policing.
Mm-hmm.
All we know is that there are these isolated or anecdotal incidents, but no one has ever proven the existence of a pattern or practice, whatever that may mean to DOJ. And so we're in this constant argument about, well, what is it? What is it that we're trying to fix, and how are we going to fix it?
Okay.
Instead of focusing on what we know is a problem, right? We know when an officer engages in a bad shooting that they should either be disciplined, fired, or prosecuted. And that happens every year. Officers are prosecuted for misconduct, and they are disciplined, and they are fired for misconduct. And the question is there basically what DOJ is saying is that there are many, 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 many more officers who are getting away with it and engaging in misconduct, but their misconduct is due to something the department is telling them to do and not their own individual behavior.
Okay. So Bob, when the Rodney King incident happened, and then after that, you had the Rampart scandal.
Yep.
LAPD, have they ever come under a consent decree?
Yeah, they were one of the first ones, and I think they were under a consent decree for about 11 years.
Was this prior or after?
It was in the late 90s, I think, is when they started their consent decree.
Okay.
And we talked a lot when we were going through our work, our stuff with DOJ. We went down to LA a lot to talk to them because nobody knows what to do when DOJ comes knocking at your door.
Mhm.
And so, but what we found is that what happened to LA under their consent decree is very different than what's happening now. I mean, the first consent decrees were much, much better because the monitoring teams were less political, less financially motivated. DOJ was less political, and the consent decree, the departments had a lot more latitude to do the reforms. Whereas now everything's political, everything's financially motivated, and departments are stuck forever.
Yeah. Hey, Bob and Keith, I got another clip I want to show real quick. We're coming up on the last 2 minutes of the podcast. And this is how the Baltimore consent decree has impacted policing. And Bob, on the other side of this, want to kind of get some of your thoughts about this.
On the streets with Baltimore police, responding to a domestic disturbance call as officers tried to gather information. The scene starts to turn. Tempers flaring after an alleged fistfight among family members. Some involved start shouting at officers. 4 years ago, police tell us there would have been arrests here. But now, a focus on de-escalation.
One of the men came in kind of hot. What does your training tell you in that situation?
Try to stay calm and try to keep the party separated.
Baltimore PD is trying to change because they have to. In the wake of the protest over the death of Freddie Gray, who died in 2015 from injuries sustained in police custody, the Justice Department took a hard look at Baltimore PD's tactics and found widespread civil rights violations. That led to the consent decree in 2017, mandating limits on use of force, enhanced civilian oversight, and more de-escalation training.
There's more of a community-oriented approach to everything.
Veteran officer Reese DeKoikoi thinks the changes are working, but a recent survey shows some patrol officers feel vulnerable.
Since the consent decree was implemented, some Baltimore cops have complained that they're apprehensive now about using force, even making a good arrest, because they're not sure if the department is going to have their back.
The perception that you have to be overly aggressive and strong to enforce law is wrong.
Ray Kelly is one of the community organizers who has helped monitor the changes.
If you were to grade the consent decree, what grade would you give it?
I would give the consent decree a C-.
Why?
I think the process itself is slow beyond slow.
4 years in and millions of dollars later, we asked residents in West Baltimore, the most violent area of the city, if they noticed change.
I have not noticed a difference. I feel like there's a lot of resistance.
Some say things have gotten worse.
When I say Baltimore PD, what's the first thing that comes to your mind?
Phoniness, aggression, targetism, racism.
But Kelly maintains there is some progress.
I can only reflect on the riots and unrest around the country following the George Floyd murder. We didn't have clashes with the police department.
And though some are critical of the pace of change, even Baltimore police acknowledge real change will take time.
It takes like a generation to see that change. You need kids to actually grow up, see what we're about, see what we do.
Trying to overcome decades of mistrust, day by day. Tom Yamas, NBC News, Baltimore.
So Bob, I mean, obviously Baltimore is dealing with there's a lot of challenges there. And you heard in that clip where the officer said, it's going to take some time. It's going to take a generation for people to look back to see if there were some changes. But these are some of the things you kind of talked about throughout the podcast that obviously DOJ really does not have. They have a method, but then that method is not very clear to even the community.
Yeah, you could do that same story in any city that has a consent decree because number one, DOJ doesn't know what they're doing. And number two, they don't have any solutions. And when DOJ starts, they start by destroying the department's reputation.
Mhm.
I mean, you just have to read the findings letter for Louisville or Minneapolis to know what DOJ thinks of those departments. And the community feels, those that are already critics of the department say, finally, somebody's saying all the bad stuff that we knew that was happening all this time. So immediately you start with major divisions between the community and the police, thanks to DOJ.
Mhm.
And it takes years and decades to come back together. DOJ's there to divide, not to unite.
Yeah.
And the other thing that's so interesting is that the champions, you know, these activists and groups that are champions of the consent decree in the beginning become the harshest critics because they realize after a few years this isn't going to work.
Mhm.
Not only is it not going to work, but it's going to make things worse and it's going to cost a lot more money. The other thing that was pointed out in that clip is that the other thing that happens every single time that is never really reported is depolicing and disengagement, right? Officers are told, pull back, do not be proactive, you know, only go to 911 calls, don't interact with people unless you have to. And officers, you know, they're told use of force is bad. So don't make as many arrests, don't have as many contacts. And the fewer contacts you have, the fewer arrests you make, the fewer uses of force you're going to have, and the fewer complaints you're going to have. And that's all DOJ cares about, are numbers.
Okay.
And if your officers are pulling back, public safety is going to suffer.
Yeah. Well, Bob, I think you had some information. Did you want to share that?
Hey, Virgil?
Yeah.
You have two questions you need to.
Yeah. Okay. Let me get to the question from one of the listeners. This is there a correlation between a strong / rogue FOP, rogue cops, and the probability of the department meeting the criteria for being placed under a consent decree?
Yeah, so one of the problems is that no one knows how DOJ selects cities for an investigation.
Mm-hmm.
They don't publish their criteria. They don't tell people we're investigating you for. We know, I mean, it's pretty obvious why they are doing it, and all it takes is one high-profile incident. So Minneapolis was George Floyd, Louisville was Breonna Taylor. I mean, you can go on and see at least one high-profile incident. Baltimore, Freddie Gray. So you can go on and on. So what happens is that once a department makes national news with one incident, that's going to attract the attention of DOJ. And all these smaller departments, all these departments that, because I've seen some reports on some really bad departments, and usually they're smaller departments that don't get any scrutiny from anybody. And you've got an obviously racist police chief and maybe 3 officers, and they're just running the town however they want. And it's like, why isn't DOJ coming in there? It's like, because it's not going to get any news, right? They want political capital out of these consent decrees. And so nobody knows. So by that measure, there's no way to avoid a consent decree, because you can be the best department in the world, as we thought Seattle was, and one incident's enough to bring them in, and once they come in, once they investigate you, they're going to find a pattern of practice. They very rarely do not find a pattern of practice. So they've already made their decision before they even started the investigation.
Okay. Well, and Bob, the other question we have in the chat room is that what's the relationship between the monitor and the judge? It seems the monitor is overstepping their role.
Again, this is all so unclear. There are no written rules or procedures for how to do a consent decree. Everyone is slightly different. But the way that I think it should be run is that the monitor should be truly independent of everyone. And a neutral view of what's happening. And all they do is they should be looking at the language in the consent decree. They should be gathering data from the department and monitoring whether they've done their policies and everything according to schedule, and producing a very dry report to the judge and saying, okay, they're in compliance here, they're not in compliance there. And then the judge should take that report and make a decision as to whether or not they're in compliance. But the monitor becomes a full party to this. So you've got DOJ, the city, and the monitor all sort of jockeying for different positions. And then they're all sort of arguing before the judge about, who to believe. And that's what's happening in New Orleans.
Okay. All right. Well, Bob, there was an incident that happened recently at a sheriff department down in Mississippi where several deputies were just terminated. One of the black males was shot in the mouth, and clearly there's you talk to people in that community that there's a history of what they believe is civil rights violation. I don't know. I mean, it's gotten some news attention, but not a lot. I mean, you just mentioned that there are these small departments, sheriff departments or municipal police departments who don't get that national attention, where there's no riots, there's no unrest in that city, and these things kind of fall under the radar. Is that been something standard that you've seen in over the years you've been involved with this?
Yeah, I mean, generally, what I've found is that the departments that get the most scrutiny from the media, from the ACLU, from activist groups, the departments that get the most scrutiny are generally the ones that are motivated to improve, right? And because they're under the microscope all the time. I mean, Seattle's a perfect example. I mean, we had civilian oversight before almost any other law enforcement agency in the country, because we had so much scrutiny and the community was calling for civilian oversight. And so we had not one, not two, but 3 layers of civilian oversight. And no other agency had that. And whereas these smaller agencies, some little town, and there may be a 10-person police department, nobody's monitoring what they're doing, and they are the authority in that jurisdiction, and nobody's going to criticize them or speak up against them. And I hear, when it does make the media, you hear about these stories, and you'll have police chiefs on video making racist comments about arrestees and stuff, and it's like that's a
problem,
super big problem that needs to be addressed, and nobody's going to help this community. Right. And they don't have the power to help themselves. So that's where, again, DOJ needs to focus their attention but they only want, DOJ wants a national press conference with the U.S. Attorney General. They want lots of media, and they're only going to get that from the big cities like Minneapolis.
Yeah. And the scary part is 80% of the police departments in the nation are 20 officers or less. Anyway.
That's right. Yeah. That's right. And there's no. Those are the ones that are most likely to have the biggest problems, because there are no national standards, right? There really is no accountability for these smaller agencies, and nobody knows what's going on. And we know that there are some bad things going on, but nobody knows, and nobody's going to do anything about it.
Yeah. Well, Bob, we definitely appreciate your time coming on and the expertise that you bring to this conversation. And Keith, Bob, he takes those comments that he gets off LinkedIn on the cheek, and it's a good dialogue. And you, as you know, Bob, you got people who agree with you and have people who don't agree with you, and I think that is what that's good about you. The fact that you bring a wealth of knowledge to this conversation, but not everybody agrees with you. But you get around the country, you do a lot of speaking to different municipalities, and I thought I was going to have the opportunity when you were up in Minnesota back last year, but the weather did not work out that good. Maybe there's another opportunity somewhere to run across you. But
it'd be great. Great.
Yeah. But I think this was a good conversation. Me and Chief Humphrey, we talked about this, and consent decrees is in the There's a lot of conversation about them, especially with what's going on up here in Minneapolis with Minneapolis PD and all the other agencies. So, it's going to be interesting, as you state, to see what the city of New Orleans do. I think if they stand up, that may kind of put some other cities in line to follow what they're going to do.
Yeah, I mean, I having been through a consent decree myself, I really feel badly for all these cities that are, because I know exactly what they're going through, what they're having to deal with, and Minneapolis in particular is in such a difficult place because you already have a consent decree with the state.
Yeah.
I mean, and now DOJ's coming in, and they're not gonna accept anything in that state. That state consent decree is going to go out the window.
Yeah.
Because DOJ doesn't take a backseat to anyone.
Yeah.
And they will roll over it.
Yeah. Chief Swag, you got anything
I appreciate Bob, and I've told cities that you would rather have a civilian review board or an oversight board than be under a consent decree.
Oh, absolutely.
Yeah.
I'd rather have anything than a consent decree.
Yeah. Well, Bob, appreciate it again. Again, we definitely thank you for your time coming on and joining us. And we want to remind those who are just now tuning into the last few minutes of the podcast. If you missed any parts of this podcast, you can definitely check out the rebroadcast on our Facebook channel. Our Facebook page, not a channel. Also, you can follow us on Spotify. Wherever you listen to your podcast, you can find You and the Law podcast to listen to this podcast and many other podcast shows previously aired. So, Bob, I will always call on you to come back on, and I appreciate your.
I never tire about talking about consent decrees. Any chance I get, I'll be there.
All right. Well, sir, we definitely appreciate it, and we will definitely be in touch with you the next time we have a conversation about consent decrees.
Great. Well, thanks so much for having me.
All right. Thank you. All right.
Get your hands up.